Hello friends, in this video I am going to discuss what are the provisions, facilities and remedies available for the victims of sexual harassments. So let's start with the provisions for victims of sexual harassment. As described by the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, the important remedies available for the victims are categorized as during the pendency or inquiry period and after the completion of inquiry. So now start with the during the pendency of inquiry period. Depending upon the choice of the complainant, the inquiry committee may recommend employer to transfer the complainant, or that is aggrieved woman, to any other workplace, other branch of the organization if other branch exists, or grant leave to the complainant, that is aggrieved woman, up to a period of 3 months. Note: the leave given to the complainant, that is aggrieved woman, under this provision would not be deducted from the leave she entitled for. Now, after the completion of inquiry, if committee found that the respondent is guilty, then it can recommend the employer to deduct certain amount, such amount as it may determine appropriate, from the salary or wages of the respondent to be paid to the aggrieved woman or to her legal heirs. However, if the employer is unable to make such deduction from the salary or wages of the respondent because he is being absent from duty or cessation of employment, then it may direct to the respondent to pay such sum to the aggrieved woman. Further, if respondent doesn't pay the sum as directed, then the inquiry committee may forward the order for the recovery of the sum to the concerned district officer. The employer or the district officer shall act upon the recommendation within 60 days of its receipt by him. Next, determination of compensation. While determining the compensation, the committee shall consider the following points: the mental trauma, pain, suffering, and emotional distress caused to the aggrieved woman, the loss in the career opportunity due to the incident of sexual harassment, medical expenses incurred by the victim for physical or psychiatric treatment, the income and financial status of the respondent, and feasibility of such payment in lump sum or in installments. Next, punishment for false or malicious complaint and false evidence. If the inquiry committee arrives at a conclusion that the allegation against the respondent is malicious, or the aggrieved woman or any other person making the complaint has made the complainant knowing it to be false, or the aggrieved woman or any other person making the complaint has produced any forged or misleading document, then the committee may recommend to the employer or to the district officer, as the case may be, to take action against the woman or the person who has made the complaint in accordance with the applicable rules. Next, if allegation didn't prove. In such a case, if the committee arrives at the conclusion that the allegation against the respondent has not been proved, then it shall recommend to the employer or the district officer that no action is required to be taken in the matter. Note: provided that a mere inability to substantiate a complaint or provide adequate proof need not attract action against the complainant under this rule. Next, prohibition of publication or making known contents of complaint and inquiry proceedings. According to the Right to Information Act 2005, the contents of such complaint, such as the identity and addresses of the aggrieved woman, respondent, and witnesses, any information relating to conciliation and inquiry proceedings, recommendations of the inquiry committee, and the action taken by the employer or the district officer under the provisions of the Act shall not be published, communicated, or made known to the public, press, and media in any manner, as it is a punishable offense. Next, the point should be noted here is, provided that a mere inability to substantiate a complaint or provide adequate proof need not attract action against the complaint under this rule. Secondly, nothing in this policy shall prevent the complainant or the respondent from pursuing formal legal remedies or resolution through government agencies or the courts of law.